This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about how Allstate fought fraudsters in court and won, and why now these fraudsters taking advantage of the no-fault system must pay damages, including RICO damages. In Allstate Insurance Company and other Allstate companies versus Vladimir Geykhman et al., the United States District Court for the Eastern District of New York on September 7, 2025, dealt with Allstate's suit seeking damages that they suffered from an insurance fraud scheme where defendants billed Allstate for medically unnecessary physical therapy services and collected insurance payments on fraudulent no-fault claims. Allstate accused several people of participating in this insurance fraud scheme, which involved billing Allstate for medically unnecessary physical therapy services. Licensed physical therapists who nominally owned the PC defendants but allowed their licenses to be used to create the false appearance of compliance with licensing agreements, and non-licensed laypersons who controlled the no-fault clinics and the medical providers they staffed. They orchestrated the fraud scheme and laundered the proceeds through shell companies. The details of the allegations against the defendants, including the submission of fraudulent claims, the operation of the clinics by unlicensed individuals, and the involvement in unlawful referral and kickback arrangements were alleged. The court recommended granting default judgment in part based on the sufficiency of the allegations and the evidence provided by Allstate. In background, the defaulting defendants, many of those who were sued by Allstate, carried out a scheme to exploit New York's no-fault insurance laws, which provide for insurance coverage to claimants involved in automobile accidents. As the victim of the scheme, Allstate alleged that it was fraudulently billed for coverage for physical therapy services. The fraud scheme was carried out through a network of fraudulently incorporated professional corporations. These clinics operated in several locations in the New York area and were implicated in one of the largest no-fault insurance frauds in New York history. The second category of defendants consists of licensed physical therapists that nominally own the PC defendants. The final category of defendants were non-licensed laypersons who were really in control of these no-fault clinics and the medical providers they staffed. The defaulting defendants failed to appear or contest Allstate's allegations and have now moved for default judgment. The burden is, of course, on the plaintiff to establish the entitlement to recovery. The court found that all three factors permit entry of default judgment against the defaulting defendants and respectfully recommended that they be deemed to have defaulted. Allstate alleged 8 substantive RICO claims that correspond with the fraudulently incorporated professional corporations that make up the PC defendants. These RICO claims are alleged against all defaulting defendants grouped by the different PC defendant enterprises and Geykhman for his role as a management defendant in control of the PC defendants. To sustain a RICO claim under 18 U.S.C. Section 1962C, a plaintiff must show 1. That the defendant, 2. Through the commission of 2 or more acts, 3. Constituting a pattern, 4. Racketeering activity, 5. Directly or indirectly invests in or maintains an interest in or participates in 6. An enterprise 7. The activities of which affect interstate or foreign commerce. There are 8 RICO enterprises at issue in Allstate's motion for default judgment, each corresponding with a PC defendant currently in default. Allstate has successfully pleaded that the PC defendant enterprises are enterprises and that the other defaulting defendants in Geykhman are persons under RICO. Allstate also moved for default judgment on the state common law fraud claims it brings against each defendant in this action. Allstate has established that the defaulting defendants in Geykhman have made material misrepresentations or omissions of fact, that they made these material misrepresentations with knowledge of their falsity and with intent to defraud, and the Allstate's reasonable reliance on these representations led it to suffer damages, and therefore default judgment should be granted as to Allstate's RICO claims. In my opinion, insurance fraud caused the insurance buying public over $308 billion every year. Insurers like Allstate are now fighting back by taking the profit out of the crime. In this case, Allstate will get money judgments against the doctors, chiropractors, healthcare providers, and the individuals who were neither but ran those crooked enterprises for the money obtained by fraud and multiple extra damages under the RICO laws. They will probably have a difficult time collecting, but they must do as much as they can to collect from the fraudsters and keep them from defrauding others. This video was adapted from my blog, Zelma on Insurance, and is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you will have access to the more than 5,150 blog postings. You can also subscribe to these videos. They're free. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance fraud, insurance law, and insurance claims, please consider, for a very small fee, subscribing to my Substack publications. And finally, please tell your friends and colleagues about this blog so that they too can subscribe. Thank you for your attention.